right, welcome back. So, in the readings for this week, we continue to look at procedural fairness, which is one of the longer portions of the course that we considered. And then we briefly look at bias. You'll see there's only 10 or so pages in the readings on bias, so it's the only portion of that chapter which you'll read before we get to the standard of review analysis, which is the thing that you've all been waiting for, where we'll actually look at in more detail what reasonableness and correctness mean. That will be somewhat simpler, I think, because it's not directly new material. So before we get to that, right, we look at procedural fairness and bias. Of course, you can supplement what we learned by reading the rest of the chapters, but we had to pick somewhere to cut in the material. So we looked at last week the nature of the procedural fairness obligation in administrative law, right? We did that actually for, I think, 2 weeks, so I won't repeat it, but the nature of the procedural fairness obligations that will apply will vary depending on essentially the circumstances. So we said there's various contextual factors having to do with the nature of the decision maker, the relationship between the decision maker and the person, and the nature of the decision being made and its impact on the person. That third one is generally the most important. And these affect the stringency, if you will, of the procedural fairness obligations that will apply. So how much procedural fairness you get. And the way in which this how much, right, is substantiated is with specific rules allowing the claimant to adduce evidence or test evidence. So they'll be able to file documents, they'll be able to make oral representations, they'll be able to complete the record, eventually they'll be able to have witnesses, to cross-examine witnesses, and eventually there'll be obligations that we'll see as to what the decision maker has to do, the nature of the decision that they eventually render in terms of what it looks like, how long it is, how much analysis it conducts. That is, as we said, inherent, comes by virtue of the Constitution, right? A statutory scheme is not dispositive for that reason, right? You cannot oust the constitutional protection of procedural fairness by statute. So even if you have a statute that says you can't do this, doesn't mean that it is right. It might be that the Constitution provides for that safeguard because of how serious the decision is. So that's why we say it's not dispositive. That being said, it's helpful because first, the government can do that to some extent. The government can limit how much procedural fairness you get, especially in administrative law, where we said it's the whole point. It's what makes it cheaper, more effective. Right? It's the fact that it's simpler, and simpler means less procedurally fair, but that can be good because it's faster, cheaper, right? And therefore more people get that procedural fairness. So the government can limit it somewhat, so the statutory scheme that is set out by the government will be helpful, if not dispositive. And also because, right, of course, whatever procedural fairness obligations you have by statute will need to be met. So for example, if the government goes beyond what would be required by the Constitution, right, then it's not a constitutional imperative, but it's a statutory imperative. So you can go to court and say it wasn't respected, and the government can't say, well, we didn't need to do it in the first place. It doesn't work that way, right? You have a statutory right to have what procedural fairness the statute provides for, and therefore that has to subsequently be respected. So we look at now some more specific, right, continuing from last week, ways in which you have procedural fairness. So the stringency of the obligation, we looked at documents, we looked at oral representation, right? We look at specific such issues. First one you have in the readings for this week are the rules of evidence. documents, and that includes, right, the two general ways in which you introduce evidence in court, which are documents and people. So you never thought it was that simple, but it actually is, right? It's the two ways in which you adduce evidence in court. You have a trial, right? What will happen at the trial? You'll have witnesses. Each side will have witnesses, and these witnesses will be there to say what happened. That is evidence. What they say is proof to some extent of what did happen, because they said it, right? If the other side says otherwise, you'll have to decide which one's right. If the person lies all the time, you might not trust them. Nonetheless, it's evidence. And second, you have documentary evidence. You submit stuff to the court on the record, right? In the record, sorry, and that constitutes evidence as well. So these are the two types of evidence that you generally have. So when we talk about the rules of evidence, again, under procedural fairness, so which protections will you have specifically regarding your evidence? The people in the documents, that is, right? So that will include stuff like cross-examining witnesses. Okay, so first, the usual rules will not apply. We'll see that's a recurring pattern. The whole point when the government creates an alternative system is that it's alternative, it's different, right? It wouldn't be much use if you created an administrative tribunal and then, right, you had all the same obligations as a court system, right? They have the same documents, same people, it wouldn't be cheaper, it wouldn't be more efficient, it would be the exact same thing. So for that reason, of course, the usual rules will not apply, including the usual obligations. So you can't say, for example, right, this document, which otherwise would be inadmissible in court, just inadmissible, meaning a person tries to file it, you can ask the court to reject it, not just ignore it, right? That's the probative value, not just say it's worthless, because it doesn't say much or what it says is wrong, right? It can be inadmissible, which means you don't even get there, you just throw it away. Doesn't even get to be part of the court record. If that's the case, right, it would not apply to an administrative tribunal. So the administrative tribunal could admit it, right, and then, right, you'd have some other argument that would apply as to its probative value, but the usual rules don't apply. Therefore, much will depend on the weight of the evidence. You see that in arbitration, for example, right? Arbitration is a consensual mechanism. Two people or entities agree to submit their dispute to binding arbitration, right? As we said, because you have a constitutional right to go to court, you have to have mutual consent to get away from that, because both of the parties will have their own right to go to court. If they want to decide that some other private person that's not a court will decide instead, they have to both agree. That's arbitration. Usually in arbitration, as weird as it sounds, there are no rules. So it's not even a matter of saying, right, the parties will say, we don't want a usual rules to apply, we want these rules to apply. Usually the parties will say nothing. What does that mean? It means the arbitrator will make up the rules of evidence as it deems fit. Therefore, you'll have the same issue, admissibility. And same thing for an administrative decision maker, actually. They can do whatever they want, unless it's provided by statute. So, why? Because first, the usual rules don't apply. Second, which rules do apply, right? Well, you look to the statute, right? So the statute might say, this is how we determine the admissibility of evidence. In that case, it will have to be respected. The statute might say nothing, in which case you're in the same position. The decision maker will make it up, because they can. As a result, much will depend on the weight of the evidence. So if you have evidence that's otherwise inadmissible in court, ostensibly there's a reason for that, right? Ostensibly it's because it's bad evidence, and that's why you don't want it to get into the court record. Well, of course, the fact that the administrative decision maker does not have to respect that rule doesn't mean that somehow this evidence will become better, right? If it was bad to start with, chances are the administrative decision maker, even though they can have it in the court record, will still find it bad, and that is by determining its evidentiary weight, by saying it's in there, but it's not worth much. It's like when someone lies, right? You've got evidence. The witness said something, it's evidence, but it's evidence to which you afford little or no weight because the witness is a liar. So the weight or probative value of the evidence will become more important because that's where, right, issues of, for instance, inadmissibility, right, hearsay, for example, that's another example, right, not admissible in a regular court. So if you come in and you say, right, I know this because this person told me, right, you cannot have that evidence of, and it gets awfully complicated when you get to the bar exam, but essentially is evidence of its substance. So you can have that, right? So I can say, John told me that Patrick is a liar. So I can say that in court as evidence of the fact that John and I spoke and that something was said. That's fine. It's not the substance. And that I can say because I was personally involved. I spoke to John. We had that conversation. I can talk about that in court. I have personal knowledge of that, right? However, I can't introduce that as evidence that Patrick is a liar. John told me that Patrick is a liar. Well, I can't say, well, because John told me it is true. That is the substance of it. That's inadmissible. So I cannot use that as proof of the fact that Patrick is indeed a liar, which is the substance of the communication. It's the rule against hearsay. And that's because, right, we don't know. Maybe John is a liar, right? Maybe John is saying something that's not true. Maybe John didn't say that. And you can't cross-examine John because he ain't there. So if you want to have that as evidence of its substance, right, John would have to come and say Patrick's a liar and explain why it is that Patrick's a liar. Same thing there. It's not inadmissible because that's a rule of evidence. So in administrative law, it is admissible. Nonetheless, it would most likely happen under the evidentiary weight. You'd say, although this evidence is admissible in administrative law, it's worthless for the same underlying policy reason that underlies the rule of evidence in the regular court system. And that is, right, that John isn't there. You can't cross-examine John, and therefore you don't know if what he said is true. Another corollary of that is that the administrative decision maker will be the master of their own procedure. I said that already, right? First, because there are no rules, therefore they can make them up to the extent that they're not provided for under the statute. Right. Nonetheless, as will always be the case, sometimes procedural fairness will come in. The rule of evidence will nonetheless need to safeguard procedural fairness. So if you have relaxed rules of evidence, again, you have lots of flexibility. But when they become so unfair that you have a breach of procedural fairness, which is an inherent obligation, then, right, the decision will be reviewable and there might be a breach of procedural fairness. For example, right, you rely on hearsay evidence too much, that's a breach of procedural fairness, because the person does not get to adequately respond to the case that's being made about them because, right, you're relying unduly upon evidence of a person who's not there and therefore can be cross-examined. It's a prejudice to the person you're using that evidence against. Then you have the right to representation, right, which we also discussed in quite a bit of detail. That means, of course, the right to have a lawyer. That's what representation means, right? And then what is the question? What is the framework? Same thing as what we saw, right? First, there will be no inherent obligation. So in the court system, for example, you might have a universal right to have a lawyer. that obligation will not apply in administrative law. So the usual rules don't apply. It's the starting point again. Second, but procedural fairness might come in. Procedural fairness might tell you, in that specific case, right, specific range of cases, say, right, a quasi-criminal procedure, for example. That's really serious. So in that range of cases, although there is no inherent right, although as a result, right, the decision maker is a master of their own procedure, there are limits to that when procedural fairness is breached. For example, right, essentially the reason why you have a lawyer in the first place is because you have no clue what's going on, right? That's what a lawyer is for. That's why everywhere else in life you get to speak for yourself, but in court you have someone talk for you, which costs a lot of money because you have to repeat stuff, right? It's the nature of the job, as you'll see, right? Your client tells you something, then you repeat it to the other lawyer, then the other lawyer repeats it to their client instead of the two people talking to each other directly. It's because there's some translation that needs to happen, ostensibly, right? It's because the stuff that the person is saying has to be translated into law for that to work in court. Well, if the court is the thing that decides if you go to jail or something else that's really serious, right, like get deported to some other country, then that translation will be very important. And therefore, sometimes it will be necessary for you to have that right, although there is no inherent obligation to provide it. Again, you'll have kind of a cost-benefit analysis that we discussed last week. Not strictly a cost-benefit analysis, more of a cost-consequence analysis. So first, what will the cost be? What will the burden of providing that additional procedural fairness be? Having a lawyer, right? That's an additional burden. It will lengthen the hearing and so forth. You weigh that against the potential impact of not having a lawyer. Namely, the person will not be able to sufficiently specifically respond to the case against them. And to the extent that the consequences of not having a lawyer outweigh the burden, the cost of imposing the right to have a lawyer, then procedural fairness might require that there be legal representation. And as is mentioned, this is it's a matter of participation, right? I didn't say it specifically, but essentially, right, the translation is important so that you can participate in the proceeding. I kind of alluded to that very closely. Sometimes when you have a charter issue, for example, Section 7, or things having to do with evidence, right, then the right to a lawyer might apply more stringently. That's also mentioned in the book. Okay, so again, no inherent obligation, fluctuating standard that might be required by procedural fairness, which is an inherent obligation. But again, all with the assumption that in the first place the rules don't apply first, and they don't apply for a reason. They don't apply because it's supposed to be simpler and cheaper. Therefore, right, far less often and rarely will procedural fairness create a specific such obligation. Two other issues that are mentioned there, you have first the right to, the right can be waived in some circumstances, in most circumstances to be exact. So the right to a lawyer can be waived if it's waived adequately, page 329. And second, it can be limited based on, say, right, your free right to choose a lawyer. So There might be circumstances where you won't have whatever lawyer you want, even though you have an obligation to have a lawyer. Another thing that's mentioned specifically is that it will vary, based on the stage of the proceedings, which is just part of the contextual analysis, right? So if it's a preliminary issue, then the impact of the decision on a person's life will be less. Therefore, on the Baker framework, right, less procedural fairness, therefore less likely to have a right to a lawyer. So the book says specifically, page 328, I think, right, at a preliminary stage, you are less likely to have a right to a lawyer. But that's not a special rule. It's just a reflection of the Baker framework, which says that procedural fairness is inherently variable depending on that same issue. Okay, then you have the rights to an adjournment, which are somewhat simpler, right, because there is no, again, general right to an adjournment. That's also true in the court system, generally. So it will, again, depend on the circumstances, which will have specific meaning in the case of an adjournment, having to do with both the impact on the proceedings first, right? So of course an adjournment is you pause this stuff, right, so that the person can do something really important, such as find a lawyer and tell their lawyer what to say. That will have an impact on the proceedings, namely that the proceedings will be delayed. That's an impact to weigh against, and there will be an impact on the other party, right, who might incur costs, for example, in their own legal representation because the hearing's delayed, and there's also prejudice to the determination of the right within a reasonable period of time. So very rarely will that be afforded. You have the list of factors at page 331, which are weighed, essentially having to do with, right, what I said, the impact on the party seeking the adjournment, the impact on the other party, and the impact on the proceedings. They're listed more specifically there, right? It says the purpose of the adjournment, good faith of the individual, right, not their fault, otherwise they don't get it. The interest of the individual and impact on their case, the position of the other parties, whether the other parties were notified, whether the harm done by the grant or refusal may be compensated, for example, by an award of costs to the other party to compensate or additional costs incurred by virtue of that, and lastly, whether the proceedings will be fair for the parties if the request is granted or denied. Works both ways again, right? On the one side, you have the impact on the party seeking the adjournment, weighed against the impact on the other party if it is granted. So that's it for, so we did 4 rights so far. We'll do some erasing there. But again, the general framework always is that you have no general obligation. Even if you have a general obligation in the regular court system, it does not apply, which means that, right, the administrative decision maker or entity will have quite a bit of control over the nature of their procedure, and, right, the specific obligations at issue, which may not exist because the regular obligations don't apply, might impose themselves by virtue of the general inherent obligation to have a proceeding that is compliant with the rules of procedural fairness. Then, right to cross-examine, same thing, right? No general right to cross-examine, namely the fact that you have no right to cross-examine a witness within an administrative proceeding is not a breach of procedural fairness because you have no right to that in the first place, no general inherent right to that. That's essentially what I said too many times so far. However, right? Again, it might, by virtue of procedural fairness, apply generally when, right, first you need to test some very serious evidence or add some very serious evidence. So, right, cross-examination will. That's, someone says something, other party gets to ask a tough question to see if they're lying. It's testing the evidence. If you don't ask a question, it might very well be that the person is lying, but we won't know it, right? We won't know it because the tough questions won't get asked. That is a prejudice to you, because the judge will think it's true because you haven't been able to show that the person's lying. Testing the evidence, again, right, on the spectrum, if it's really important evidence, central evidence, right, it will, it might well be that you have a right to cross-examine a witness by virtue of the general procedural fairness obligation. Same thing if it might reveal, the tough questions that is, right, the existence of important evidence, again, because if you don't get to reveal it, it will be prejudicial to your case. It's also important on major issues of credibility, of course, often credibility of the claimant, the person facing the administrative system, right? So if the person's own credibility or reputation is likely to be in jeopardy, page 332, right, then they might have a right to cross-examine the witness. Lastly, is the right to reasons. As we said, right, of course, generally the whole point of administrative law is that, again, it's simpler, more efficient, blah, blah, blah. Therefore, right, the decision will not look like a court decision. It's a general rule. It is unlikely to. For example, you go to government office, you get denied a driver's license. The person might just say, you do not meet the statutory criteria. They might say that verbally, they might say that in writing. That does not look like a court decision. It's not detailed, doesn't analyze the law, so on and so forth. It's a general framework in administrative law. Not only do you have no right to reasons, reasons being the rest of the decision, that's not the one sentence that says what the disposition is, generally you will not have reasons. Nonetheless, again, same thing, no general right to that. Nonetheless, sometimes procedural fairness will impose such an obligation, and that's by virtue of, right, the stuff we saw in the Baker case. So you have certain factors which are stated progressively in the book, page 335. First, when it's necessary to understand the decision. Okay, so the point of the reasons is generally that it helps you understand the decision. So the long piece of paper that says why it is that you were denied a driver's license or whatever else. It's helpful because it tells you why. It doesn't just tell you what the result is, it tells you how the decision maker came to the result. To the extent that that is very important, it will apply. So, what do I mean by that, right? I mean that you generally always have a right to know how the decision was made. That will vary depending upon the importance of the decision, how much transparency you get into why the decision was made. Will vary depending upon the importance of the decision. If it's really important, right, then you'll have more right to more insight into why and how the decision was made. However, you always have a right to know to some extent why the decision was made. We said the court, right, because, the court has to assess the reasonableness of the decision. The reason why you have to know why the decision was made. First, it's not fair if you don't. But more importantly, it is an issue of reviewability. When you get to a court and you say this is not a reasonable decision, the court, if it has no idea why the decision makers say denied you a license, has no way to assess whether or not that decision was reasonable. We said there's mechanisms for the court to do that. For example, by looking at the record. So if you have a one sentence, doesn't mean it's the only thing you have, in which case it wouldn't be reasonable. Because you wouldn't know how to say whether it's reasonable or not. You might have a right to go to the record. The court, if it doesn't figure it out with that sentence, will go to the record. We'll go to the evidence. We'll try to piece out how the decision maker decided without speculating too much, because that's prohibited, as we'll see. And if it can then assess whether it's a reasonable decision or not, you're fine. To the extent that, as a result of that, the record does not provide for a sense of how the decision was made, you're more likely to have a right to more extensive reasons, because you have a right to know what happened, and because the court, upon judicial review, has to be able to assess how that decision was made. Okay, so that's mentioned as a separate criterion of appeal / review, right? So if it's a decision where you have a right to an appeal or judicial review, or conversely, if it's a really important decision where you're likely to have to seek judicial review, again, more likely to have a right to more extensive reasons. Because there's no inherent obligation, you can still have statutory obligations as always, right? So if the statute that creates the administrative decision maker says that you have a right to some sort of an explanation or reasons, that will apply, of course, right? Government doesn't get to say after that it wasn't required by the inherent constitutional obligation of procedural fairness. If it's provided for by statute, again, you have a statutory right, not a constitutional right, a statutory right, which has to be respected and can therefore be infringed upon. Okay, there's quite an extensive discussion of the adequacy of reasons, which we won't directly get into, but you have a right, by virtue of this ability to understand how the decision was made, right? That might impact in some way the form of the reasons, and you have the Northwestern Utilities case that's mentioned there. Sorry about my handwriting today. Page 338. Essentially, right, to the extent that, say, there's an imperative to have reasons. So to the extent that there's a need for there to be more than one sentence, because the record, because the importance of the decision, for example. The decision will have to be what we call under Vavilov intelligible, understandable. So it won't be sufficient for the decision maker to just repeat the evidence. Say, right, Mr. X said this, Mr. Y said this, I decide as much. It's not sufficient. You have to do the math, right? You have to understand how the decision maker took the inputs, right, the stuff that was said, and use that to come eventually to a reasoned decision. So the substance of the decision, the form of the decision, will have to tell you how it was made, right? Otherwise it's useless, and therefore you don't meet the obligation that you otherwise have to have some sort of reasons. Okay, page 342, right, is reiterated that, and I mentioned that already and indirectly, but the importance of the decision on the person's life will at times, right, often actually, right, also influence the nature of the reasons. And that's because, right, procedural fairness will require that the person be more likely to understand to a greater extent, right, more disclosure as to how the decision was made. Then you have delays, which are another way in which you can have an inherent procedural fairness obligation. So another way in which the general procedural fairness obligation can manifest itself. Generally, right, it is unlikely that you will get a suspension of the proceedings, right? That you'll get a stay of the proceedings. More likely that you'll get a suspension. We mentioned that last week. So it would have to be an extremely abusive delay that is often, right, unrelated to the complexity of the case. Because of course, if it's more complicated, it takes more time. That's not the agency's fault, right? Not the bureaucrat's fault, it's the case's fault. So unrelated to the case and essentially imputable to the decision maker, generally speaking, right? It will have to be an abuse of power by the agency and essentially cause, if not willingly, by a fault that's directly imputable to that agency. And that's why you have, right, the discussion, page 345 or so, of bad faith, right? Doesn't have to be bad faith in the sense of a subjective negative intention. That's what bad faith means, right? Bad faith means evil. So you intend to do something bad. Doesn't have to be that, but it has to be really close. It has to be, right, the agency's fault. It has to be a really serious fault such that it's almost as though it were evil or intentional. Page 348 is where you have the criteria that I just mentioned regarding the complexity of the case, right? So you have, right, the time taken compared to the inherent time. So if it's generally a slow process in administrative law, I'll write it down here. Page 348 is where you have the criteria. So compared to the procedure. So if it's usually a long procedure, it's less likely that it will be abusive for you to have an even longer procedure. The contrary, right, is a short procedure, opposite. Compared to the complexity of the case, as I mentioned. And third, the impact of the delay, right? The impact of the delay on the parties. Usually, we only have, for example, these kinds of obligations in the criminal law because there's a big impact on the parties, right? There's a risk that they'll go to jail. For that reason, their life is basically unbearable when they're facing criminal accusation, and that's why criminal charges. That's why we create an imperative that they be judged within a reasonable period of time. Okay, another way in which the procedural fairness obligation can instantiate itself is by the identity of the person who makes the decision. So generally there is an obligation for once, right? Not the absence of an obligation. There is an obligation for the person who hears the case to decide. What does that mean? It means the person signing the administrative decision has to be the person who conducted the proceeding. That kind of just makes sense, right? Of course, because if they were there, they heard the witnesses, the evidence. If they delegate the decision-making power to someone else, it's a breach of procedural fairness in the sense that it's as though the proceedings did not happen, right? That person does not have, that second decision maker, does not have the same familiarity with the evidence and what happened, and therefore, right, they're less likely, it's as though, the procedural fairness obligations that required these proceedings in whatever form they took were useless because that person does not, right, have that familiarity, therefore it's prejudicial to the parties. Okay. Then there's an issue of courts, administrative tribunals, hiring counsel for themselves. Not that important for our purposes. What is important for our purposes is the consolidated Bathurst case, which is the extent to which you can have decision makers consult each other. So that's what the case says. So what happened there? You had some decision makers who talked to each other, essentially, through a consultation process. That was held to be fine. So, how does that happen generally? Missing syllables there. Independence. So, if you can read it, I'd shed it. So, what happens? You have a decision maker who conducts the proceedings. So they hear the witnesses, they see the evidence, as usually decision makers do. So they have to decide, right, by virtue of the general rule. Then they ask their colleagues. They talk about the case. They can do that. That's what the case says. So they can talk about their colleagues about, right, how tough the case is. They're allowed to do that, even though the parties aren't there. Why are they allowed to do that? Because it doesn't affect their independence. Because they don't have to ask their colleagues, and because what their colleagues say does not have, and in fact most often won't, affect their own decision, which is what you have a guarantee of. Essentially under bias, which we'll see in the next chapter, impartiality, right, doesn't affect their independence, and that's why it is permissible. For that reason, right, in the Tremblay case, which is the opposite of that, if you mandate consultation, not mandate that you, as a decision maker, listen to what you're told in consultation. That would, of course, not be permitted. But if you mandate participation in consultation, so you mandate that the decision maker show up to some place with other decision makers, that in itself is already too much. It compromises their independence because they don't go there willingly, and therefore is not permissible under that case. Now it's also because, as we'll see, there is the protection of bias, independence, impartiality, all the same thing, right? If you have a personal interest in a case, right, or if you look like you have a personal interest in a case, or if you say something wrong that makes it sound as though, that's all the same thing. It's independence, impartiality, which you have a right to. You have a right to a decision maker who is detached from the stuff and able to make a decision independently. That decision maker, right, what we protect under that, as we'll see in the next chapter, is not just the factual lack of independence or impartiality. It's not just when, say, they take a bribe or they make money based on the outcome of the decision. It's also when there is an appearance of impropriety. And that's why, even though when you have mandatory consultation, it might very well make no difference on the subjective mind of the specific person whom you're mandating consultation for, that doesn't matter. When you mandate consultation, when you have a decision maker that is forced to talk to other people, it looks like their independence will be compromised. It looks like they'll have to, right, talk to these people and therefore listen to them. And even though there might very well be no subjective impact on their subjective mind, might make no difference, there's an appearance of, right, a lack of independence potentially. Okay, end of the chapter. We are back to the standard of review. So, 3 factors as we said. First, the decision maker. The nature of the administrative entity. So the nature, the circumstances of the administrative entity and the decision it tries to make will impact the level of procedural fairness and therefore the standard of review. Second, the relationship between the administrative decision maker and the individual. And third, the impact on the person, right? The impact on their right. That is how you determine the stringency of the procedural fairness obligations that will apply. So, in other words, whether you get lots of procedural fairness or not. As we said under Baker, right, the Supreme Court essentially said that it was confused. So the Supreme Court seemed to suggest that the standard of review for a decision of procedural fairness was beyond the standard of review analysis. That you had to determine what I just said, how much procedural fairness applies, and then, of course, whether or not these obligations were met. The Supreme Court seemed to suggest that that was neither correctness nor reasonableness. So technically, under Vavilov, as we said multiple times, there is a presumption of reasonableness review which is supposed to apply to procedural fairness. But no one really knows, but it seems like the Supreme Court suggested that. It's actually different. It's Baker. It's Baker that says this is the standard, and therefore there's no need to resort to procedural fairness or to reasonableness or correctness. And you'll see the author himself isn't really clear as to what the Supreme Court actually said. And he even says specifically, I think the Supreme Court needs to add further guidance or clarification on that following Vavilov. Okay, nonetheless, generally, there will be some deference to the administrative decision maker by virtue of everything we learned so far in this chapter. We said the various things that you have under procedural fairness, the various instantiations of the general inherent right to procedural fairness pursuant to the Canadian Constitution, right? Examination, adjournment, reasons, all the stuff we saw. We said all of those don't apply inherently. The regular rules don't apply inherently. Generally, they don't. And, right, that's because administrative law is supposed to be simpler, cheaper, more efficient, all of that. Therefore, the court will be somewhat deferential to that. To the fact that it's supposed to be simpler, and also to the fact that the administrative decision maker will have leeway to decide how much procedural fairness you get. So we said, in the absence of a constitutional imperative protecting some procedural fairness, and in the absence of a specific statutory entitlement to a specific measure of procedural fairness, the decision maker will be the master of their own procedure. They'll be able to decide how much procedural fairness you get. Therefore, because of that power, upon judicial review, the court will be more deferential. So kind of more like reasonableness will allow for that decision to be made by the decision maker, right, within a range of outcomes. Will allow for it to limit procedural fairness a bit more than it normally would, but not too much, at which point it infringes upon, again, the inherent procedural fairness protection. And that's it for Chapter 6.